Hello, everyone. Thanks for joining us tonight for this important conversation. I'm going to give everybody a few more minutes to log on and we'll get started very shortly. Welcome, everyone. My name is Katie O'Connor, and I'm the Deputy Chief Counsel at Demand Justice. Thank you all for joining us for this important discussion about the threat to voting rights and democracy at the Supreme Court. This year, the court's hearing two cases that could drastically impact how elections are run in this country. In the first case, the court could gut what's left of the Voting Rights Act and make it much more difficult for voters of color to challenge election laws that dilute the strength of their votes. In the second case, the court could give gerrymandered state legislatures nearly unlimited authority over how federal elections are conducted. There's a lot to unpack about both of these cases, and we're lucky to be joined by experts from Common Cause and Elias Law Group to help us unpack it. But first, we have the honor of hearing some opening remarks from Congressman Jamie Raskin. Congressman Raskin has represented Maryland's 8th congressional district since 2017, and he is a tireless champion for his constituents and for our democracy. Congressman Raskin serves on the House Judiciary Committee, the Committee on Oversight and Reform, the Rules Committee, and the Committee on House Administration. He's also the chair of the Oversight Subcommittee on Civil Rights and Civil Liberties and chair of the Rules Subcommittee on Expedited Procedures for the 117th Congress. And over the past 2 years, Congressman Raskin has also served on the House Select Committee on the January 6th attack, where he's helping investigate the attack on our nation's capital and the role that the former president and his allies played in that attack. He has stood up for our democracy time and time and time again when it was in most need of defense. Let's hear what he has to say. Looks like we're having some technical difficulties. Give us just a second.
Transit, Demand Justice, and Common Cause and the Elias Law Group. Thank you for getting together to talk about the democratic emergency we now face with Moore versus Harper, where the Supreme Court could conceivably overturn a couple of centuries of jurisprudence and electoral law practice and custom by deciding that the state legislatures in this independent state legislature doctrine can basically do whatever they want outside of their state constitutions, outside of the state constitutional regime within which they're embedded. And as you know, the case comes from North Carolina, where there was a severe and egregious state legislative gerrymander for congressional districts, basically creating 10 Republican and 4 majority Democratic districts, 10-4 in a state that's pretty much evenly split. And although the Supreme Court has pulled itself off the field in terms of policing gerrymandering, the North Carolina Supreme Court struck down this redistricting as an egregious and deliberate gerrymander against the people of North Carolina. And now the question the Supreme Court is facing is whether the North Carolina Supreme Court can do that. In other words, whether it can adjudicate gerrymandering claims or any kind of election claims under the state constitution, or whether the independent state legislature doctrine protects the right of the state legislature to do whatever it wants. And I see this very much in the context of what happened in 2021 on January the 6th, where the GOP determined that the linchpin, the keystone of all decision-making would be the vice president. And it had been overlooked for 2 centuries, but suddenly the vice president has the power to step outside of his constitutional role, overseeing the counting of electoral college votes, and can unilaterally, lawlessly, extra-constitutionally just vaporize electoral college votes from Arizona, from Georgia, from Pennsylvania, from anywhere he wanted to. And of course, this was completely contrary to the historical practice, the text, the structure, the meaning of the Constitution, and our whole democratic experience. And it's the same thing now. I think some people view that there's a partisan advantage in inflating the powers of the state legislatures to the size of a Goodyear blimp and radically uprooting the state legislatures from the federal and the state constitutional design, just because it will give them some short-term political advantage. But of course, this doctrine is wholly illusory and fanciful, and I'm glad that you're getting together to talk about it. It does relate to a certain extent to what we did in the Presidential Election Reform Act. We're trying to come up with legislation between the House and Senate to deal with at least the most severe and outrageous efforts that took place on January the 6th, increasing, for example, the threshold by which members get to challenge the receipt of electoral college votes from a particular state. Also clarifying that no, the vice president does not have the unilateral power to run away with the whole presidential election. But also in the Presidential Election Reform Act, we are saying that the state legislatures must appoint electors pursuant to a state law that was adopted before the election took place. So they can't take up the invitation of somebody like Donald Trump, who said, oh, well, just disregard the popular vote, repeal that statute, and pass a new statute, just appointing the electors for me, or coming up with some new system for doing it that will benefit me. And if the independent state legislature doctrine is right, Congress would not be able to do that, theoretically, hypothetically, would not be able to do it. But you see what's going on there. There's an effort to basically wrest away from the people the choice of who wins the electors in a particular state, and to nullify the vote of the people in the electoral college process, which fundamentally has got to go because it creates all of these opportunities for strategic mischief by bad faith actors. It's given us 5 popular vote losers as president twice in this century. So I'm proud that the very first bill I introduced as state senator was for the National Popular Vote Interstate Compact. In Maryland, we are more than halfway there in terms of the states joining the interstate coalition to cast our electors, not for the winner in our states, but for the winner nationwide. That will be an ultimate solution. We've got to keep the whole trajectory of democratic reform and enlargement and improvement moving, so we get closer to a more perfect union, as opposed to lapsing into authoritarian and autocratic ways of doing business just to favor particular politicians or particular parties. So I thank you for what you're doing to analyze this case and other related cases like Merrill versus Milligan. We need to be defending the right to vote, fortifying majority rule, strengthening democratic institutions against coups and insurrections, electoral sabotage, extreme judicial activism, and of course, political violence. So thank you for what you're doing, and I wish you very great and excellent and productive proceedings today. Thanks, everybody.
Thanks again to Congressman Raskin for speaking with us tonight. And now let's get started on our conversation. I'll start out by briefly introducing our illustrious panelists for the evening. We are joined tonight by Kathy Fung. She's the National Redistricting Director for Common Cause. Common Cause is a plaintiff in the Moore versus Harper suit, one of the two cases we'll be discussing tonight. Kathy has been with Common Cause since 2005. She was the former executive director of Common Cause of California, and prior to that, headed the Voting Rights and Anti-Discrimination Unit at the Asian Pacific American Legal Center. We're also joined by Ava Khanna. Ava is partner in the Elias Law Group's litigation practice. Very recently, she argued Merrill versus Milligan on behalf of a group of Alabama voters. That's the other lawsuit that we're going to be talking about tonight. But she is also counsel of record for a set of parties in the Moore versus Harper case. She worked at Perkins Coie for 11 years before joining Elias Law Group, and I found this fascinating. She is a former high school English teacher. So welcome, Kathy and Ava. I'm going to try to leave some time at the end of the hour to take some questions from the audience. So if you have questions, feel free to go ahead and put them in the Q&A section or in the chat. But for now, we'll get started. So I'm sort of grouping this into two pieces, grouping them out by the case. So the first case we're talking about is Merrill versus Milligan. It was argued on October 4th of this year. And again, that was argued by Ava. So Ava, in a nutshell, what are the legal issues in this case?
Hi, thanks, Katie. Yeah, the legal issue in this case is in some ways very straightforward. This case is about the Voting Rights Act, Section 2 of the Voting Rights Act, which requires states must not create laws that deny or abridge the right to vote on account of race, and must instead have voting laws that provide an equal opportunity to access the political process and to elect preferred candidates of different racial groups. We brought a lawsuit in Alabama challenging Alabama's congressional map, which has 7 districts, only one of which allows Black voters an opportunity to elect. Despite the fact that Black voters now the Black population in Alabama is now about 27% of the population. And in establishing our claim below, we did this before a 3-judge panel, we basically marched through a very well-trod path and a well-established legal standard that the court has created and that has been in place for nearly 40 years. And I'll just quickly back up. Back in 1980, the Supreme Court, when adjudicating a claim under Section 2 of the Voting Rights Act, said that plaintiffs would have to show intentional discrimination, racist discrimination, in order to prevail on such a claim. 2 years later, Congress came back and amended the Voting Rights Act to say absolutely not, and to disavow that idea, and created this idea of this results-based test, which basically again looks at the opportunities of different racial groups to participate in the political process. The Supreme Court came back and adopted that test and refined that test and created a really kind of methodical way of establishing a Voting Rights Act claim. It is in equal parts straightforward and very burdensome for plaintiffs. It requires a bunch of expert analysis. Basically, plaintiffs will have to establish they can come in with an illustrative map in which Black voters or minority voters would be able to be a majority of the voting age population. Requires us to establish racially polarized voting and white bloc voting. And it requires us to establish a host of historical and social and political conditions on the ground in a jurisdiction that basically amount to a Section 2 violation. We followed all of these steps quite meticulously below, and before a 3-judge panel in Alabama got a 235-page opinion basically saying that we have gone through all the steps and this is not even a close case on a Voting Rights Act violation. Alabama's appeal is really, the heart of the appeal is really not about whether or not we have proved our case under the existing standard. Rather, it is an appeal to the US Supreme Court to change the standard. Basically, the theory being that it's too easy for Section 2 plaintiffs to win, and therefore the court needs to now change the test that's been in place for nearly 40 years and make it more difficult.
you can't help but sigh when you hear stuff like that. Kathy, I'm going to go to you. Where do things stand now with the Alabama maps, and how is the status of this case impacting the election in 2 weeks?
Yeah. Well, unfortunately, for November 2021's election or 2022's elections, those federal congressional maps that were drawn by the Alabama state legislature are in effect. So those are the maps where, despite the fact that 1 out of every 4 voters in Alabama are Black, there's only 1 out of 7 congressional districts that have a majority of Black voters. Specifically, what that means is that Black voters in places like Mobile, Alabama, Montgomery, Alabama, the rural Black Belt, who were spread out across multiple congressional districts, 1, 2, and 3, they are living in places where literally their votes are diluted. And there are other places where, like District 7, where Black voters are hyper-packed into a single district. It's caused a lot of concern, right? It's caused a lot of frustration. But there are a lot of activists in Alabama who are also organizing, and they're not going to let a temporary defeat in one court or a slowdown in one court silence their voices. And so I'm really pleased to say that there are a lot of groups like Alabama Forward and Alabama NAACP and Greater Birmingham Ministries that are organizing people to get out to vote, to rally so that their voices are not erased. And if folks are interested in kind of finding out how they can lean in on some of the efforts around this, they can go to powerontheline.org, where a lot of those groups are coming together around this very case to say, we will not allow our voices to be erased. It's a rallying call. It may be a long fight. We'll see what happens with the court decision. But I know that there are a lot of people who are saying, we're not laying down for this one.
Thanks. Abba, you had this great quote during the oral argument. You said, quote, "To answer the question of what do I understand the state's position to be, I have to say I'm not entirely sure." What did you mean by that? And what do you now think Alabama is asking for here?
I think it is and was a little unclear because, and even the justices, I think the reason I got that question from one of the justices is because they too, I think, were a little confused. There were certainly, there were moments in the brief and certainly during argument where Alabama was taking a very aggressive approach that basically said, let's reinsert the intent test that was abandoned, 42 years ago by Congress and this court, and now make that the new standard again. And I think, in many ways, the Alabama arguing counsel really did kind of double down on that idea. I think the justices did not seem very pleased with that notion. And then I think so they started to try to see if they could pull back to Alabama's maybe slightly less dramatic, but equally dangerous, I think, arguments. And that would include anything from requiring plaintiffs at step 1 before they can even get into the door to provide some kind of a race blind map, some kind of a race blind alternative that doesn't take race into account. And if that sounds counterintuitive, to basically come into court with evidence of a racial discrimination in voting without looking at race, that's because it is. And so, I think they suggested that that's what plaintiffs' new burden should have to be. They also suggested that maybe the defendants can come in and show some kind of race blind alternative would have resulted in something that looks like the map that's being challenged. There's a theory that these kind of race blind alternatives should have a role in the totality of circumstances analysis kind of later in the process. I think it was a bit of a moving target. And at the end of the day, the central argument was, well, if Alabama got caught up in a Section 2 violation, clearly it's the test that's wrong, and we need to change the test so that we can kind of get to a different result, kind of however we get there. So I think it was a bit of a moving target, and I'm not sure till today that I still know really what their main approach was, or if they're really trying to throw everything at the wall and see what sticks with this court.
Kathy, you've been doing this work for a long time, and Justice Kagan made the point that the court itself has repeatedly moved the goalposts when it comes to the Voting Rights Act. So in Shelby County in 2013. It essentially gutted Section 5 of the Voting Rights Act and told us to rely on Section 2. And then a few years ago, in a case called Brnovich, it suggested that Section 2 was limited to vote dilution cases. And now here, there's the possibility that it'll further limit Section 2 even in those cases. Can you talk a little bit about that?
Well, so we don't know what's going to happen with Milligan v. Merrill. So we can't prognosticate whether or not they're going to continue chipping away at the protections that the Voting Rights Act provides or changing the standard by which people can bring challenges. But we do know that the makeup of the court has been shifting, right? And we've seen some other cases that are very troubling. We also know that in the larger zeitgeist, right, the politics of today, there is an active readiness by politicians to say that somehow we can resolve and solve racism by simply ignoring that it exists at all, right? And that's where the term race blind comes from, but it really is saying we're going to pretend like it doesn't exist, even though we all know that it does, and we all know that it creates advantages for some, right, and severely disadvantages the Black community and other communities that under institutionalized racism, right, where government policies have reinforced attitudes and discriminatory practices, that we really see the biggest brunt of how that lands on people. What I'm going to say is that as a result of this series of cases, there is a positive silver lining, which is that people are so much more attuned to what I call the plumbing of democracy, right? You usually don't pay attention to what's behind the walls, but right now we're all paying attention to it, and people are really rallying for changes, right? They're not just asking for changes to the policies, but also the way that we pass them, the way that we elect our government, the very underpinnings. They're saying that if we want our Constitution to mean something, it is important for redistricting to be inclusive. It is important for our voting laws to be written in ways that are protective of rights, but also it's important for those people who are elected to those offices to be elected in a way that is as transparent and inclusive as possible. I have ultimate faith that our democracy is strongest when people actually act and speak. And we have the opportunity to strengthen laws in the states through state-based voting rights acts. And we also have the possibility of passing a federal resolution in things like passing the John Lewis Voting Rights Act and strengthening and restoring the Voting Rights Act. I think that sometimes we need to course correct. And what it demands is that we not take things at face value or for granted, but we step up. And there's a lot of ways that people can step up by signing petitions, writing to their electeds. You can't necessarily do that for the Supreme Court, but you can do it through your congressional members and through your state legislators. Elections can be, a person can put their finger on the election process, but we also know that when we have overwhelming participation by voters of all political stripes, that it can also change outcomes. And that's what's important. People should not feel like they are depressed or, that it's useless to participate, because it really matters.
If I could just jump in as well. I mean, I love the positive message. I totally agree that, we can't just feel defeated by the fact that these issues are in the ether, but rather empowered and mobilized to get out the vote and make these changes. But on the question of these various ways that Justice Kagan mapped out, that there's been some chipping away of the Voting Rights Act. Section 5, that's been controversial for a very long time, that kind of federal oversight provision. Then you could say, the Brnovich case, it was the first time Section 2 had been applied by the Supreme Court in that kind of context, the time, place, and manner context. But in Milligan, when it comes to redistricting and Black voters in Alabama, this is the kind of bread and butter Voting Rights Act case. It's what the Voting Rights Act was built on, and what this doctrine was built on. And it's as I said, the court below said this is not even a close case. This was an easy case to decide, not an easy case to litigate, because it really just falls so squarely within what Congress intended, what the court has intended for decades.
Yeah, and But I think it's worth mentioning, right, that the court below, we're talking about a federal court made up of 3 judges, and those 3 judges are by no means sort of people who are to the partisan left. They are, 2 of them were appointed by Trump, right, and the third one is a Republican as well. So these are people who said, yeah, no, this case is pretty much textbook Voting Rights Act violation, right? And they unanimously said, you know, this needs to be redrawn. So we'll see what the Supreme Court does.
I'm going to ask one sort of law nerdy question here. This is, of course, I'll ask Abba this first. This is, of course, one of the first cases Justice Ketanji Brown Jackson has heard. And she seems to be trying to meet the more conservative justices where they claim to be, using the language of originalism to analyze the case. So I wonder if you have any comments about that.
Yeah, I mean, that was amazing. I think on that oral argument day was October 4th. I think that was her second day on the bench. And it was great just to see. I mean, she came out swinging. She was certainly no shrinking violet. That, you know, just as a newbie, she had, you know, she was really, I thought, thoughtful in her questions of both sides, and clearly had done her homework. And there was this time, a point at which she basically kind of educated all of us, I think, in the courtroom on, like, let's step back and go to the 14th Amendment and talk about when the 14th Amendment was adopted. Was anyone talking race blind? And this notion, you know, how those founders, the framers of the 14th Amendment would be astonished to hear us saying today that the wellspring, that the Voting Rights Act, born of the 14th Amendment, born of the Reconstruction Amendments, 14th and 15th Amendments, is all of a sudden that might possibly require a race blind showing, when there was nothing race blind about what led up to the 14th Amendment, of course, and to its ultimate adoption. They, the ratifiers, the founders, the framers were trying to solve a problem of racial discrimination across the country, you know, in many aspects, and specifically with the 15th Amendment, with voting. And she came kind of point by point with quotes from the history to show that no one was thinking about this post-racial colorblind world. They were thinking about, we have a problem of black and white, and how do we solve that?
All right, we're going to shift gears now and get into the second case, Moore versus Harper. This case is going to be argued at the Supreme Court on December 7th. The Supreme Court is still live streaming audio of its arguments, so I would encourage anybody who has a few spare minutes and enjoys this kind of thing to listen in. But Kathy, this case is at its core about a gerrymandered congressional map in North Carolina, and it's obviously become about a lot more than that, but I wanted to start at the beginning. What is the underlying issue in this case?
It's hard to give you a short story because North Carolina's history of gerrymandering is so long. When you think about the seminal cases around partisan gerrymandering and racial gerrymandering, they start in North Carolina. So a little primer on North Carolina. Number one, North Carolina is a purple state, and it has been evenly split between people who vote Republican and Democrat, and a very large portion of people who are unaffiliated, probably because they're just tired of it all. Fact number two is that North Carolina has been ground zero for racial and partisan gerrymandering for decades now, and it's been carried out by the majority party. Now, in some years that has been, in some decades, that's been carried out by the Democrats. Most recently, it's been carried out by Republicans. Fact number three, in recent decades, Republicans controlled the majority of the state legislature, and so they controlled the redistricting process, both in the 2011 cycle or 10 cycle, and also this most recent 2020-21 cycle. So let me give you the short version of this, right? The short version is that Republicans were caught red-handed engaging in racial gerrymandering in the 2010 redistricting cycle. They were told by the courts that they had to redraw, and so they came back and they said, oh, we've redrawn these lines and we're now drawing them entirely for partisan gerrymandering, partisan advantage, and not for racial reasons, right? And we've gone and drawn 11 Republican districts and 10 Democratic ones. We would have drawn 11 if we could have, but we can't, because we can't squeeze one more out. So that was their pronounced reasoning for why they were drawing the lines. And so we actually brought a case to the Supreme Court and we said, hey, that's not right. North Carolina Supreme Court. And the North Carolina Supreme Court said, you're right. They have gone too far. This is partisan gerrymandering, and it violates our North Carolina Constitution. Of course, the legislature didn't like that solution, so they went all the way up to the Supreme Court. Supreme Court took a look at it, and they said, they took a half step in our direction, right? They said partisan gerrymandering is in fact a scourge of American politics. It has to be addressed. We're just not sure if it's the federal courts who should be addressing it. But Chief Justice Roberts did write the majority opinion saying maybe there are other places that we can look at that where you can properly address it. State constitutions, state action, state judicial review. And so that's exactly what we did, right? And so what's interesting is that this most recent cycle in 2021, it starts all over again, right? We had good maps, the courts redrew. And then in 2021, everything kind of starts all over again. And the legislature hasn't learned its lesson, right? They decide we got to do this. We've got to draw the extreme thing. That by now, North Carolina, because of population growth, has increased its number of seats, but they're still trying to put their finger on the scale and give themselves an extreme advantage. And in the process, they slice up Black communities in a part of North Carolina. And so once again, we had to bring a lawsuit, right? And along with Avocano's group and many other plaintiffs, we challenged those districts. And once again, the court said, nope, this is a partisan gerrymander. And we told you before, our Constitution says that's not allowed. So the upside was that, you know, we got a good decision out of the state Supreme Court. The downside is that once again, like babies, the legislature couldn't accept what was told to them. And so they've thrown a temper tantrum and they're like, you can't be the boss of us, right? And they don't want the Supreme Court to ever tell them what to do again. So we have a situation where I think you have an out of control legislature that wants what it wants and it wants it all. Doesn't like to share its toys in the sandbox. And meanwhile, we've got, you know, multiple efforts that have gone to the courts to try to rectify the problem.
Thank you. So, Abba, what is the current status of this underlying issue, and what does it mean for this year's elections?
Yeah, I mean, I really appreciate the history that Kathy just laid out. I think that's really telling of kind of how we've gotten to where we are. And I've had the privilege of working on the racial gerrymandering cases, the partisan gerrymandering cases last time on behalf of alongside Common Cause, including Harper 1 last cycle, which after the Common Cause legislative partisan gerrymandering case went to the congressional map, that was found to be a partisan gerrymander by the North Carolina trial court and revised. And here we are with Harper 2. And we, along with, in partnership with the National Redistricting Foundation, who's been our partner throughout these litigations in North Carolina and in Alabama, brought this on behalf of Harper again, just like as Kathy said, same story, different day. But interestingly enough, you know, both Merrill v. Milligan and Moore v. Harper were tried in January of this year. So there's a lot of juggling on our legal team as we're kind of watching both of these cases go up the ranks. And this one went to an expedited trial that, as Kathy mentioned, we've got the North Carolina Supreme Court ultimately said this is a blatant partisan gerrymander. Unlike Merrill v. Milligan, however, when the state defendants who had lost appealed to the Supreme Court saying, not only do we want you to hear our case on appeal, we want you to stay the win below and stay the proceedings below. In Alabama, the Supreme Court did do so. They stayed the case. And as Kathy mentioned, now we're under the old map, a challenged and unlawful map for 2022 in Alabama. In North Carolina, they did not grant that stay. They agreed to hear the case, but said, no, the North Carolina state court's decision holds for the next election. So the good news is that for 2022 in North Carolina, the congressional map is not the gerrymandered map that has been found by now multiple judges at the at the state court level to be a partisan gerrymander, and it's going to be under the lawful map that has been the remedy to that gerrymander imposed by the court.
Yep.
Kathy, you sort of alluded to this earlier, but it's notable to me that Common Cause was a party a few years ago to a case called Common Cause versus Rucho, in which the Supreme Court said that the federal courts don't have jurisdiction to hear partisan gerrymandering cases. So is it fair to say that part of the reason this was in state court, part of the reason this is in state court to begin with is because the Supreme Court stripped the federal courts of jurisdiction?
Yeah, I think that's exactly right. The majority opinion written by Chief Justice Roberts said that, that their conclusion doesn't condone excessive partisan gerrymandering. They said, right, and it doesn't condemn complaints about redistricting to echo in a void, right? And then he goes and lists out the various things that are hopeful, on many fronts, they're being actively addressed. So he talks about, how Florida's courts struck down partisan gerrymandering based on an initiative that was adopted and put into the Florida Constitution. He talks about how the framers gave Congress the power to do something. And then he also talked about how state statutes and state constitutions provide standards for people to apply, right? For the state courts to apply and for legislatures to follow. And so what's interesting is that he specifically points out, that states are, the laboratories of innovation, and we should go back to the states. And that's exactly what we did, right? There's a series of cases. Common Cause v. Lewis challenged the state legislative cases. Harper 1 challenged the congressional cases. And we went through the state courts to say, okay, state courts, that you're our only venue, apparently. And in fact, the state court looked at the mountain of evidence that was in front of them and once again said, yep, that evidence shows that there has been partisan gerrymandering. Those lines need to be redrawn, and they need to be redrawn in a way that is fair. And they were able to do that, I think, in North Carolina, but also in multiple other states, right? So Pennsylvania followed suit, right? There are multiple states where that was the avenue, and that's what we took. And I should just mention that in multiple states also adopted alternatives to the state legislature drawing the lines, because Chief Justice Roberts noted that that was one way of solving partisan gerrymandering. And so you have states like Michigan and Colorado, right, that he noted adopting independent commissions, but afterwards multiple other states also saying, yeah, us too. Like, so Virginia adopts its own kind of hybrid commission in order to address partisan gerrymandering.
Yeah, thank you. So Abba, this leads us to what has become the bigger and perhaps more alarming issue in this case, the so-called independent state legislature theory. So what is the independent state legislature theory?
At its most basic, the idea of this independent state legislature theory is because the Elections Clause of the US Constitution charges state legislatures with regulating the time, place, and manner of federal elections. So the theory goes that therefore state legislatures act with basically unconstrained authority when they're doing so. And that includes in drawing congressional maps. And what that means is that they are not answerable to their own state constitutions or their own state courts. That those constitutional provisions that might put a restraint on their authority are nullified, and that any state court that might act as a check on the state legislative authority in the arena of federal elections has no role to play. So that, I think, is at its most kind of fundamental. In the course of this case and the briefing and the argument that we've now seen before the Supreme Court, we've seen the North Carolina legislature kind of try to weave a little bit around the really kind of rock solid centuries worth of precedent that has debunked that, or that has disavowed that idea, to say, well, okay, maybe we can walk it back a little. Maybe it means that state courts can apply procedural provisions, but not substantive restrictions. Somehow they believe that the veto kind of falls in one, but the ordinary state court review falls in the other. Maybe state courts are allowed to review very specific constitutional provisions, but not vague ones, or ones that are not, or I think vague was open-ended, or I think is the word that they use. And here, of course, the North Carolina Supreme Court did what state courts do all the time, which is interpret its own Constitution, including a specific provision called the Free and Equal Elections Clause, which has no federal analog, including its First Amendment, including its Equal Protection Clause, more broadly than the federal Constitution, and to rely on its own history and precedent to say that this is something that under our law, this is how we interpret our Constitution. So we've seen a little bit of zigs and zags and kind of how they've tried to maneuver this theory in this case so that it would try to capture what was happening in North Carolina. But really, at its most basic, it's that the legislature gets to have unchecked authority, kind of contrary to our entire system of government.
Kathy, Congressman Raskin sort of referenced this a bit. The independent state legislature theory was part of former President Trump's attempts to overturn the 2020 election. And a lot of people are worried about this case and what it could mean for attempts to overturn future elections. Can you talk about the role it played in 2020 and the role it would likely play in future elections, depending on what the court does here?
Sure. Obviously, I was not in the room when all of the craziness was happening. But what I will say is that there are a lot of people who were in close circles who shared with us that there was an active effort to try to advance this theory of independent state legislatures, that they could swap out, ignore what the vote of the people in their state was, and swap out the electors for whatever group of electors they thought would be appropriate in order to give President Trump the electoral win despite the vote. That theory was advanced as a way of, as a backstop if Mike Pence was not going to do something also unconstitutional, that they could kind of lean on this. It was an extension of an interpretation about the electors clause, which is a little different than what's at issue here, which is the elections clause. But the general idea is, shouldn't the state legislature, since it's named in the Constitution, be able to do whatever it wants when it comes to that particular clause? Thankfully, there were cooler heads that prevailed in those inner circles. And what we know is that people like Judge Ludig, who, by the way, signed on to our brief that was submitted on our side to say that it's bunk, right? It's bunk. It's an entirely fabricated idea that state legislatures could step in and swap out electors. And whether or not it plays, certainly what I'll say is this: it should not be at issue in this case. And hopefully we don't have any candidates who decide that they want to invoke it, because we've already gotten pretty close to it. And there was a universe of people who said that is an entirely inaccurate and unconstitutional interpretation of that clause. It doesn't give supreme power to the state legislatures to swap out and ignore people's votes. And so too, we would say that the elections clause doesn't give absolute power. I think that you have to understand what powers the state legislature has, in part by looking at each state's constitution, right? And those constitutions tend to be very detailed about what the state legislature can do, what the bounds are, and that's exactly what the courts are interpreting. So it's not sort of an unbound power. And so too, state statutes and other kinds of forms of our laws delineate what power a legislature could do and cannot do. We do not live in an oligarchy. We don't live in tyranny. And the reason why is because we have a respect for the fundamental rule of law. The phrase "no one is above the law" means something in the United States. And that means that when it comes to the elections clause, it does not give unbound, unrestricted, unchecked powers to the state legislature. We still have 3 branches of government, last time I looked, and they should mean something. They check each other. And that's how come we still, in many different ways, every time we feel like one thing is out of balance, there's another body of government that checks it. And that's really important to making our democracy as sustained as it has been.
Thank you. Abba, what should we expect when the court hears oral arguments on this case on December 7th? What can we look out for? What are you looking out for?
Yeah, I mean, I think maybe not unlike a lot of cases, particularly in the voting rights area, we're going to be looking for, in particular, to see kind of where Justice Kavanaugh, where Justice Barrett, where Chief Justice Roberts, where their questions are lying. What are their concerns? Obviously, there's at least 4 votes that got to the agreement to grant certiorari in this case and to hear the case. So we want to see kind of what was motivating, what are the questions that are really on their minds. I think we're going to see a lot of questions into the constitutional history, whether this was ever contemplated by our founders when they drafted the elections clause, and as we've done and as we've made clear in our brief, this is it's all, the history is really just almost speaks with a unilateral voice when it comes to this independent state legislature theory was never had any purchase at that time. And I think we can also see a lot of a lot of questions about the kind of practical consequences of the theory for congressional redistricting, for election administration generally, and trying to understand how does this kind of square peg of a theory not only not fit within the kind of constitutional history and the legal precedent, but really with the conduct of elections as we run them, and understanding kind of what would it mean if we were to kind of blow that all up. At this point, I think that I hope that there's that kind of interest to figure out of, there are a lot of plot holes, I think, in this independent state legislature theory generally, and in this case in particular. And I think we'll be looking to see if the justices are really interrogating into those plot holes to see if this, regardless of what you think of how it sounds, how does it actually work, and to find out that it does not.
I have one more question before we get to audience Q&A. So please go ahead and put your questions in the Q&A function or in the chat, and we'll get to as many as we can. But Kathy, I know that Common Cause and Southern Coalition for Social Justice are doing a lot of the organizing work that is necessary to both win this case, but also to make sure that people in North Carolina and across the country understand the implications and what we can do to push back. I know some people in the audience here are interested in learning what can be done to push back. So can you tell us about that work?
Sure. If you live in the state of North Carolina, we have been doing a 100 county town hall tour where coming to a town near you, there have been active conversations about Moore v. Harper, but also how important it is to understand when you're casting a ballot in this upcoming November elections, why it makes a difference, right? And connecting it to issues that people care about or that they're living with on a day-to-day level. That conversation has been very vibrant, and we're working to capture people's stories to be able to tell the story of why something sometimes that happens that feels very far away in the Supreme Court, the distance, the elitism, right? It really can have a direct impact on our everyday lives. I'm going to say that, for a lot of people, the other thing is to try to raise that conversation that's happening in your town or neighborhood or on a webinar, right? By hosting a conversation just like this one, right? And some people have also leaned in to write letters to the editor, and I'm going to pop a link into the chat box really soon in case people want to lean in to do that. It's important to stimulate that conversation. The last thing that I'm going to say is that if people have the wherewithal on December 7th, it's tough to get into the Supreme Court, but it is very easy to get to Washington, D.C., or it can be easy. We're creating opportunities for people to join us at a rally, right? The rally is important whether you're in Washington, D.C., or in multiple cities that we're going to have other rallies in North Carolina, Ohio, other places, because I think that our elected officials, maybe not the Supreme Court, because they're insulated, but the elected officials who think that they can get away with dismantling our US Constitution and state constitutions by giving themselves absolute power need to understand that that is an unacceptable power grab. And it's unacceptable to voters. It's unacceptable to Americans, regardless of political stripe. This is not a Democratic or Republican issue. It should be something that fundamentally, as Americans, we don't accept. And so it's important for us to join rallies, to write to letters to editors and tell them checks and balances matter. Three parts of our government, right, should have separation of powers and check each other. And most importantly, no one body of government should have all the power to be able to pass laws without any supervision, without any oversight. I'm going to pop that link into the chat in case anybody is interested in writing a letter to the editor.
Perfect. Thank you, Kathy. We did get a question earlier about Merrill versus Milligan and whether the Alabama state legislative maps are also gerrymandered, whether there's a state legislative analog to what's happening at the Supreme Court.
Oh, yeah, the state case is going on. And in fact, actually, just I think like a couple days before the Supreme Court argument in Milligan, or actually not this couple days before, on the same day, there was oral arguments before the state court about the legislative maps, and those are continuing to be challenged in state courts.
And I think, Kathy, the argument is that's for the North Carolina legislative maps, right? That those maps were part of the exact same case and have been, as she mentioned, going forward in the state court. I don't know if the question was also about Alabama. There is also a pending Section 2 case against the Alabama legislative maps as well. I think everything's kind of been frozen and put on hold there pending the outcome of Merrill v. Milligan, but there's a pending case there as well.
Thank you. We also had somebody who asked about the Florida redistricting maps. I don't know if either of you know the status of those. Okay, great.
That's us. So we are also plaintiffs in the Florida case. And in that case, just as a little bit of background, this is an interesting one because Florida has a state constitution that has been amended by the voters to adopt the Fair Maps constitutional amendments. And it specifically says partisan gerrymandering is not allowed. You cannot favor or disfavor incumbents or a party. And the courts sort of have interpreted that. And so the state legislature first came up with maps that were relatively even-handed. They said, okay, so we've been chastised by the courts before. We understand that we shouldn't go too far. So they started out by adopting or discussing maps that were fairly even-handed. And then over the course of time, Governor Ron DeSantis decided, perhaps egged on by partisan interests coming out of Washington, D.C., that he should ask for more and more and more. And he bullied the state legislature into adopting extreme partisan gerrymanders and lines that ultimately sliced and diced the African-American community in the panhandle of Florida. We are currently in court right now challenging that gerrymander, and the court we're essentially proceeding. It's slow, but I will say that we are in the process of, the court is still live, the case is still live, and we're in the process of moving through the motions to get into discovery.
Great. As I said, the experts are obviously here, able to answer all your questions. There's one more question that we have that I think we have time for. When would we expect Moore versus Harper to be decided? And this is a specific question. How will it affect Michigan Citizen Redistricting Committee? And will it affect all elections or just federal elections? But I wonder if you can sort of expand on that and talk about what it does mean for those sort of specifically independent redistricting committees in other states.
Well, I think we wouldn't expect, I mean, we're going to have argument in December. I think we can expect this to be, one of the cases that we'll hear toward the end of the term. We'll get the opinion in this late spring or summer, and certainly no later than June, hopefully. And then we'll know a lot more. In terms of what it could mean, the actual outcome of this case would affect this case. It would affect the North Carolina congressional maps. It does not affect the state legislative maps in North Carolina or anywhere else, because again, this is about the elections clauses, authority given to state legislatures over federal elections. And so there's really no question, they've not raised an issue about whether or not the same theory could apply to state legislative elections. In terms of independent redistricting commissions or other kind of ways that states have really crafted their constitutions, crafted their laws, citizen initiatives to fight up against partisan gerrymandering or its possibilities. I don't think those are not going to be decided in one fell swoop. Depending on how broad this opinion is, but most likely they will not all be decided in one case. But depending on whether or not the court is willing to entertain this, it certainly opens the door to just the next challenge and the next challenge. And I think this is really exactly what we're talking about. We're thinking about what are the real consequences of this? What would this mean if you're able to say that this was invalid? What else would then fall down when it comes to constitutional protections for federal elections?
Yeah, I like to believe that when the voters have spoken, 75% of Michigan voters voted to say yes, they wanted that Citizens Redistricting Commission, and similarly in multiple other states like Colorado and California and Arizona, and they put that language into their state constitution and in some cases state statutes, but it's a voter passed initiative, or a referred initiative, but it doesn't matter because voters voted on it, that they should be sacrosanct. I don't know what the Supreme Court will end up doing, but they should be sacrosanct because it is a double whammy of embedding it in the state constitution, but it's also something that voters directly passed. I think that, so what I'll say is that is a road that we hope that will continue to be protected. And, we're looking at multiple other states where if that's our solution, we will be hard at it to adopt more constitutional changes to create citizen redistricting commissions and protect redistricting in other ways from the machinations of hyperpartisan actors.
Well, thank you. And we are hitting the end of the hour. This has been wonderful. Thank you, Kathy. And thank you, Ava, so much. And I do want to encourage everybody who's listening in to go and check out the links that Kathy has put in the chat. And also, if you want to keep up with all of these cases, follow Common Cause, Elias Law Group, and Demand Justice on social media. And I'm putting, oh, no, I'm not putting that in the chat anymore. Anyway, follow us. Definitely, I encourage you to take the actions that Kathy laid out. We would love to see some of you on December 7th at the Supreme Court. And in the meantime, everybody take good care and thanks for joining.
Thanks for hosting.
Thank you, Katie.